All right, everybody. I do apologize. We had a bit of a technical difficulties this morning, but rather than to keep everyone online and work through those, we're actually going to switch things up this morning and start with Carol. But I do not want to take away from my introduction, so thank you again for joining us this morning for another installment of our webinar in the COVID-19 series of webinars. For those of you that are new to the webinars, my name is Jason Flynn, and I am the Director of Human Resources and Client Services for Prestige Employee Administrators. Our tax manager, Carol Sawyer, joins us again this morning. And we also have a newcomer to the webinar this morning. Her name is Kimberly Milerva. Kimberly is a partner of the Ruskin Moscow Faltichek law firm, and we are certainly happy to have her with us joining the webinar today. As for today's agenda, we will be focusing on the return to work parameters. Kim will be talking about recalling employees from furlough, managing employee illness and child care leave issues, addressing employee fear, as well as some wage and hour concerns. Originally, from that point, we were going to hand it over to Carol, where she will summarize some key points around the Paycheck Protection Program. But as I mentioned, we are going to start off with Carol today and hopefully get to Kim right after Carol. So just as a reminder, all participants will be muted throughout the webinar. However, if you have a question, I do urge you to use the Q&A feature within the webinar and direct the questions to the panelists. We'll do our best to answer all of the incoming questions as we normally do. And of course, a copy of the presentation will be available in the COVID Resource Center of the Prestige website following the webinar. So at this point, I'm going to hand it over to Carol to take it away.
Hi, good morning, everybody. I've decided to change things up a little bit. There have been so many details to all of the changes that have happened with the Flexibility Act that was passed and the application and the EZ application, then instead of doing a Q&A format, I'm just going to highlight the points that are most asked about. And so we're going to start off with what we thought was a deadline. All of the legislation said that yesterday was the deadline for being approved. The Senate stepped in very late yesterday and approved an extension to August 8th. However, the House has not done anything yet, and therefore it has not been signed by President Trump. So for those of you who have not yet applied and been approved, you may still have a possibility. There is still a fair amount of money left in the program. Covered period. It begins on the day the proceeds are deposited in your bank. It's not when you're approved. It's not any other day than when it is deposited in your bank, with the exception of businesses that pay on a weekly or a bi-weekly schedule. Those are the only two candidates for selecting the alternate period, which means you can start your covered period on the first day of the next full pay period. Now, due to the fact that they clarified the language saying that costs that are paid or incurred, the necessity for the alternate covered period isn't as great, because that first paycheck that is a part of the covered period is fully covered, and then you can also do the accrual for at the end for those few paydays at the end. But the covered period, for the most part, begins on the day the loan proceeds are deposited. Now, loans that are approved before June 3rd, which is when the Flexibility Act was passed, you get to choose between 8 weeks or 24 weeks, and those loans approved after June 3rd use the 24-week covered period. Now, a big question has been, how do I choose? When do I need to choose? When you complete the forgiveness application and you write what your covered period is. You either write down an 8-week period or a 24-week period. Start date, how you decide the start date of the covered period does not change, but the end date will either be 8 weeks or 24 weeks, unless you came in after the Flexibility Act, and it's 24 weeks. The Flexibility Act changed the percentage. A minimum of 60% of the loan proceeds must be spent on payroll costs, which is wages, state and local taxes, and employee health insurance and 401k contributions. The remaining 40% can be spent on mortgage interest payments, rent or lease payments, and utilities. Definition of utilities has never been changed. It is primarily gas, electric, phone, internet. There is a transportation factor to it that has never been fully defined. But those are what that amount can be spent on. A little bit of math, you know me, there's always got to be a little bit of math when I'm involved. So what does this 60% mean? How does this really come into play? Well, let's say you had a $100,000 loan, and you spent $55,000 on payroll costs. That's as much as you could put together in your 8 weeks. Well, you take $55,000 and divide it by 0.6, and that will give you a maximum forgiveness of $91,667. That is besides any FTE reductions or the wage and salary reductions. This is so important to remember. There is no deadline to apply for forgiveness. Yes, there was a huge rush to apply for the loans because you were worried about money running out. There is no rush to apply for forgiveness. You already have the money. The interest is deferred until the date that you're notified that it's forgiven. So once again, you don't need to rush. What about the interest? The interest on the forgiven amount is also forgiven. They do give you a bit of a limit, but this is very attainable. If you do not apply for loan forgiveness within 10 months after the last day of your covered period, the interest is no longer deferred at that point and payments need to be made. So while there's a soft deadline of 10 months, that is plenty of time to get all of the reports ready and to submit the application to your banks. And I don't believe any banks are ready at this moment to accept forgiveness applications because they are still getting guidance from SBA. One key point for borrowers who are using the 24-week covered period, you may apply for loan forgiveness prior to the end of it. So let's say you've chosen the 24-week period and after 11 weeks you don't have any money left. You've spent it all. You can apply for forgiveness as of that date. However, we are awaiting further guidance on the FTE reduction as it applies to 24 weeks if you apply for forgiveness before the covered period is over. Other key points, employee cash compensation. If it's an 8-week covered period, it's $15,385, and for the 24-week period, it is $46,154. Please, we apologize for the typos in the slides, the proofreading. I didn't get it done as well as possible. Owner employees, that's a little bit different. When the loan applications first came out, the guidance indicated that owners and regular employees were all treated the same, and now with the release of the forgiveness application, we realize that is not the case. So the total compensation for owner employees is capped at $15,385 for 8 weeks and $20,833 for the 24 weeks. If you were with us last week, Seth and Malcolm took us through an exercise that explained the SBA and Treasury's reasoning behind the $20,833. It's basically 2.5 months of your 2019 compensation. They didn't want any businesses playing with the numbers and laying off and trying to pay themselves more. This was the purpose, again, as I've said from the beginning of this loan program, was to protect the paychecks of employees. And then last bullet is talking about that they are eligible for forgiveness if they are paid or incurred and paid on the next scheduled check date. This goes for payroll costs and for utilities. Utilities are always paid on a monthly basis. Rent is a monthly basis. So you can take that period that wasn't paid until the next check and include that in your forgivable expenses. Owner employees, a category of much confusion, and I'll do my best to shed some light because every entity is a little bit different. So what is an owner employee? Practical sense, they're S corporation shareholders, partners, members of an LLC, and self-employed individuals. Anyone who has an equity stake or a revenue income stake in the organization. S corp shareholders, partners, and members of LLC that are filing as partnerships will receive a K-1, which has an income, self-employment income portion to it. So those are owner employees, and so you are now treated differently. You're not in the regular schedule of employees on the Schedule A worksheet. Your compensation will be reported on line 9 of Schedule A, and the cap on that I discussed on the previous slide is an all-encompassing cash and benefits. Yes, there was that guidance in the beginning that the $100,000 was the cap on cash compensation only, and that is how it applies to employees. Owners of an S corp, your health insurance is included in your wage compensation when the wages are grossed up at the end of the year on your W-2. So that was already considered in the loan application process. Partners and members of an LLC that files a partnership and self-employed individuals, health insurance costs for you are handled differently. So that is not included in any way in the amounts that you will put on the application. And then the third bullet, just to mention, payments for health insurance and qualified retirement plans are not added into the amounts that you are reporting paid on behalf of the employees. So owner employees, the logic changed a little bit with the application, forgiveness application release. FTE, that's another complicated, and in some ways, SBA and Treasury is trying to make it a little easier. They recognize that the economic rebound that everybody was hoping for has not occurred and cannot occur due to the virus at this point. First of all, reductions due to a voluntary resignation, a voluntary reduction in hours, or you are allowed to fire for cause. You don't need to keep somebody because you're worried about reducing your FTE count. So these are all exceptions in calculating your FTE. Have I met what my look-back period was? You also get an exception for you've made a good faith written offer to the employee to either restore the hours or to rehire them, and they have refused. The latest released interim final rule does indicate you must notify unemployment that you have offered employment to this individual and they have chosen not to come back. So that was something that was added just recently. The wage and rate reduction calculations, keep in mind that's only the rate. We don't want to double penalize you. So if somebody was still getting paid $30 an hour, but you were paying them 30 hours instead of 40, that reduction, that's covered in the FTE calculation. You would not have a wage reduction hit as well because you didn't reduce their rate. Now the safe harbors, they're qualifying and adding language for the FTE safe harbors. Now, instead of needing to wait for December 31st, that was the date that was in the Flexibility Act, you need to restore your FTE as of the date of the loan forgiveness application submission. So they once again recognize that it's about restoring everything now, not trying to carry it through or restoring it again at the end of the year. And then there's a second safe harbor. that if you were unable to operate at the same level that you did as of February 15th during the covered period due to the various shutdowns, and this can be an indirect or a direct result. Let's say you sell school supplies. Your primary customers are the public schools. Well, those are shut down. So while you're still open, you can't operate at a normal level of business because you have nobody to sell to anymore. So they're, once again, really understanding that you can't hire people if you can't sell your product or do business as you're used to. So they've provided a much better safe harbor catch-all to help people apply and get full forgiveness. A couple of questions that have come up is very often, gee, after my 8-week covered period, I do my application, I need to lay people off or I need to furlough. There is no effect on forgiveness at that point. They once again realize that you can't, business hasn't been restored. Restaurants are not allowed to open up still, or they're opening up a limited capacity, and so obviously everybody that sells to those organizations, we just haven't rebounded yet. So there is no effect on forgiveness if these people that you rehired and paid with the loan are then laid off. One thing we don't know are the people that are using a 24-week covered period and you apply before the end of the 24-week period, are you responsible for maintaining your FTEs to the very end? We do not have exact guidance on that. I don't expect that to be the case. All of the guidance issued so far and all of the updates that they've given, that would not be the case. But we do not know that officially. And again, a big question that's being asked of a lot of our employees is, which is better for me, 8 weeks or 24 weeks? That is not something we can answer for you. You need to look at your numbers. Here at Prestige, we do have that report that we can run for you for every payroll to show what your forgivable costs were. The majority of our clients are smaller businesses, so you know if you've let somebody go, you know if you've reduced somebody's wages, the rate that they're paid. So you have all that information. If you have spent the money and you haven't had reductions, there's no reason not to use the 8-week period, but that is up to each business. Here's the good news. There is a new application. It's the EZ form. Who can use this? Well, first, employers that did not reduce their salary and wages rates by more than 25%. And once again, that's just for employees making less than $100,000. If you had somebody who was making $160,000 and you cut them down to $110,000, that's not going to count against you in any way. And if you did not have any FTE reduction from January 1st through the end of the covered period, you can use this application. Well, that's pretty hard because a lot of people laid off and then rehired when they got their loan. That's okay. That brings you in under the second bullet point. You didn't reduce your rates by more than 25%, but you were unable to operate at the same level due to the various shutdowns and economic impacts of COVID-19. So you are now, if you can say that, you are eligible to use this. It is a simple 2-page application. Only one page has numbers on it. The second page is just signing off and initialing on the various attestations, and then that's it. You will, of course, still need to provide proof of payment to your bank with those, so the reports that we provide you that show the payroll costs that were spent and the benefit costs and the, if you had qualified retirement plan matches, those documents will still need to go to your bank, but it is a much easier application. Now, the point has been made in other webinars, well, how do I know if I didn't have an FTE reduction? Obviously, for larger businesses, you're still going to need to do a little bit of math. And so, yes, Prestige will be providing reports that give you all the information for the full application that will then allow you to decide, can I use the easy application when I apply for forgiveness? So that was a huge step, I believe, that SBA and Treasury made by doing the easy application form. And that wraps up Paycheck Protection Loans. Stay tuned. You know, you'll be hearing from me as the month of July goes on. But that will be it, and hopefully this will put all your minds at ease so you can enjoy your 4th of July weekend.
Thank you, Carol. So at this point, Kim, are you with us?
Yes, can you hear me?
We can hear you, and we love to hear you right now. So,
terrific.
Perfect. I am going to slide on back to your slides.
Terrific, thank you.
Get things, absolutely. Carol, thank you so much for reviewing the key points, going over those summaries of what we've spoken about over, this is our 14th webinar now. Clearly, there's been a lot of things we've been going over, and when it comes to loan forgiveness, you know, this is something that we've spent a lot of time to, you know, work with our attorneys, our partners, our clients in providing the information that we need to. And listen, a lot of times it gets muddied up or changed or altered in some way, as you can say. You know, things happen minute by minute. So thank you for going over those summaries. At this point, what I'd like to do now is, as mentioned, Kim is with us. Kim, as I mentioned earlier in the webinar, Kim is a partner at Riskin Moscow and Faltacek PC, and she chairs the employment law and digital media practice groups. She's also a member of the firm's litigation department. I know that she definitely works a lot with employer and employee relationships. These are her areas of expertise, and we are very happy to have Kim with us to go through returning at the workplace and what that means to everybody at this point forward. So Kim, I am going to turn it over to you.
Great, thank you so much, Jason, for that introduction. We're going to jump right in to our returning to the workplace issues. Many people are dealing with everything. If you want to switch to the next slide, that would be terrific. From recalling employees from furlough and returning remote employees to the workplace and what is involved in opening a safe and compliant workplace. And then, of course, once employees are back at work, dealing with employee illness and issues concerning refusals to return to work, and dealing with also those high-risk individuals and complying with the necessary laws. And then finally, addressing some pitfalls and liabilities that may result from a changed workplace as a result of COVID-19. So we're going to start right in with recalling employees from furlough. If you want to switch, thank you. So as far as bringing employees back from furlough generally, and certainly during this time, this is a time in which we've heard the term furlough more than ever before, certainly in as far as non-union workplaces go. And generally speaking, furlough means employees who've been put on a temporary leave from active duty, but they've remained as employees. And due to a loosening of rules from insurance carriers, many of them have remained on the employer's health insurance benefits and they are collecting unemployment at this point. And I compare that with employees who may have been laid off over the period of time since COVID began. And the distinction really is that with laid off employees, although of course you still may seek to recall laid off employees, generally speaking, the employment relationship was severed. And if you're going to bring those employees back, you would be rehiring them. Those employees, if they were entitled, would have been given or offered COBRA, and they too have been on unemployment. So when making plans to bring employees back from furlough, there's a few steps you need to take to make sure you're doing so in a non-discriminatory way. Of course, if you're bringing back an entire workplace or entire departments, the issue of discrimination becomes less important, but many employers are seeking to be protective, or what they deem to be protective of employees, by perhaps not electing initially to bring back high-risk workers And we'll talk about that in a few minutes in terms of what the CDC is determining to be high risk. But generally speaking, that implicates possible disability and age-related issues. And so while employers may think that they're protecting high-risk workers by not asking them back, at least at this point, you have to be very careful to not end up resulting in a discrimination claim, because employers are not really supposed to act in that sort of protective way towards employees, although they certainly can make it more voluntary or give the employee who is known to be in a high-risk category the option to return if there is that type of concern. When employers are bringing employees back, frequently they are sending recall notices or recall letters to these employees, and this is a great opportunity to lay out any changes that may be in terms of the employee's salaries or benefits or any other terms and conditions of employment as they're returning to the workplace. And this also can apply to returning remote employees back to the workplace. This is also a good opportunity to ensure that employees confirm that they're going to comply with whatever safety protocols you're putting in place, and we're going to talk about that in just a second. And also to give employees comfort, to let them know the types of things that the employer is doing in order to maintain a safe workplace. So what is that we need to do? There are a lot of safety protocols that are being put in place and that are required for employers to open back up their workplaces. New York has sector-specific guidance for every industry or most industries on the New York State website. And in fact, employers have to review the guidance and they have to electronically submit an affirmation. If you haven't seen it, you have to scroll all the way down to the bottom of your specific industry guidance. And you have to sign an attestation confirming that you review the guidance and that you understand your obligation to operate in accordance with the guidance. So that's step one. The second step then is to make sure that you have and you've developed a written safety plan. So the state has a template on the website, which we do encourage our clients to use because at least you know then that if you're audited or somebody comes to check on your plan, that you have completed all of the components that are required in the New York Safety Plan. So you have to conspicuously post the safety plan, and it has to be available on site in case the Department of Health or local authorities come in to look at it. And of course, so that it's available for employees. And the types of things that are in the safety plan that are required, for example, in office-based businesses, some of the guidance includes density requirements, no more than 50% of maximum legally permissible occupancy at any time. So that doesn't necessarily mean 50% of your normal workforce. It's based upon the occupancy of the location. So if you are in leased space, that's something that if it's not posted, speak to the landlord and try and figure out what the occupancy maximums are so you know how many people can come in. There's also social distancing requirements, PPE. Employers have to provide face coverings at no cost to employees. This is an issue that's come up with some of our clients. They have sought to charge once if someone loses or has their PPE destroyed. You must provide adequate PPE to employees at no cost to the employees. Of course, there's rigorous hygiene and sanitation practices that's required. And there's also mandatory health screenings for employees and visitors. And that is, at a minimum, a 3-question inquiry where employees or visitors have to confirm whether they've been in close contact in the past 14 days with anyone who's tested positive for COVID-19 or who has had symptoms, if they themselves have tested positive for COVID in the past 14 days, or if they've experienced any symptoms of COVID-19 in the past 14 days. If the answer to any of those questions is yes, that person should not be permitted in your workplace. Employers are also required to immediately notify local health departments about any positive cases. And this, along with logging all individuals actually who have close contact with others in your workplace, is an effort to support the contact tracing that is required in New York. So any visitors that come in, you need to make sure that you have contact information for those individuals so that if such a report becomes necessary, you have all that information available to you. Not only is this all important, of course, because we don't want to get sick and we don't want our employees to get sick, but we also have to be very aware that any company that does not comply with these rules is potentially subjecting themselves to significant liability, both from employees who may get sick. There might be negligence claims, perhaps worse, any other type of tort claims you can think of. And I also believe that you could be in have significant risk of liability if there is some sort of inspection that takes place and you fail to be abiding by these policies. A lot of employers have inquired about waivers, and I've seen this a lot, both from employers and also just in public generally. When you go into certain locations, some businesses are requiring people to sign waivers. We don't know how this will play out in court yet, of course, because this is all new. But my expectation is that if you are not complying with the elements of the required safety plans and of the guidance for your industry, then the waiver is not going to be upheld, even if it's signed by the individual who may get sick. So with regard to testing, a lot of employers are inquiring about whether they can require their employees to be tested for COVID-19. And the answer is yes. So long as it's consistent with business necessity, you can require employees to be tested for active COVID-19 infection. However, the EEOC has recently come out with guidance that says that antibody testing is not found to be consistent with business necessity. And so you may not require employees to be tested for the COVID-19 antibodies. And even if employees do voluntarily get tested for the antibodies, employers are not permitted to use those results for any purpose. So my advice, I would not even inquire about the results of these tests because there's no legally permissible purpose right now for your use of those results. And so there's no purpose in asking for it. Okay, so we're going to move on now. Now that you have employees back at work, it's sort of inevitable that at some point you'll likely need to deal with employee illness and child care issues. And so the first acts and matters that we're going to speak about are the legal requirements under federal law. And so Families First Coronavirus Response Act, this first went into effect on April 1st. And now that employers are starting to ramp up their workplace in-office work, this is starting to become a much more prevalent issue once again. And this act applies to employers with fewer than 500 employees. Employers are responsible to pay at the outset for the costs associated that I'll discuss in a moment with these leaves, but it's fully refundable through tax credits, which will offset the cost of compliance. This is basically broken into two components. The first is the Emergency Paid Sick Leave Act. All employees are eligible for this paid sick time, and it is up to 2 weeks or 80 hours of paid time available. And there's two elements. The first is for the employee who is either subject to a quarantine order, is experiencing symptoms and is seeking a diagnosis, or somebody who's been advised by a healthcare provider to self-quarantine because of concerns related to COVID-19. These employees are entitled to their full pay for 2 weeks, up to a maximum of $511 per day. The second category is people that are caring for someone else. So if an employee is caring for another individual who's subject either to an order of quarantine or someone who's been diagnosed or seeking medical diagnosis, that employee is also entitled to up to 2 weeks of pay, but at the rate of 2/3 of their regular salary to a maximum of $200 per day. That same leave benefit of 2/3 salary up to $200 per day is applicable to employees who need to take leave because their child is unable to either attend school or their regular child care facility, or now camps that are closed due to COVID-19. So in this scenario, for this child care leave component, the child doesn't need to be ill. It is just if the parent does not have another child care option because of COVID. And so that is, again, for the first 2 weeks. Now, first, just with regard to the emergency paid sick leave, which I'm talking about right now, even if somebody ends up with more than one basis for the leave, let's say, for example, back in April, somebody took 2 weeks of leave to either to care for their a sick family member or for their own illness, and now let's say they've come back to work and they have a child care issue. If they have used those 80 hours under the Emergency Paid Sick Leave Act, the Department of Labor says you only get one bite at this apple. So it's 80 hours total under the Emergency Paid Sick Leave, even if it's for different reasons. There's also certain requirements for documentation for these various types of leaves. And that documentation is important because in case you're audited for the tax credits, you're going to make sure that you want to make sure that you have all of your documents in order. So with regard just to the child care leave element, there is also the second aspect of the Families First Act, which is the Emergency FMLA Expansion Act. And what this does is it makes available to employees an additional 10 weeks of extended leave, and all of this leave is work protected. So you can't terminate somebody during this time, with some exceptions, but generally speaking, it's job protected. And so if somebody, again, doesn't have care for the child due to COVID-19, they would be eligible for another 10 weeks of paid time at that same rate of 2/3 of their salary, up to $200 per day. One thing I'll note is that this FMLA time, it does go to the same maximum cap of 12 weeks in a 12-month period. So if you have an individual that already took FMLA earlier in the year or within the 12-month period for whatever reason, and let's say they use 6 weeks, they would only have an additional 6 weeks available to them under the Expansion Act. You should also be aware that there are some exceptions to the child care leave component for small businesses with fewer than 50 employees. But the exceptions are very narrow and fact-specific and would have to be looked into on a case-by-case basis. There's also the Americans with Disabilities Act and state law that applies to anyone that may need additional leave time off based on a disability, unpaid time off, or other types of accommodations. So you need to be aware of that. And then there's New York State law. New York State provides for quarantine leave. As I just mentioned, with the Families First Act, there is a fairly broad range of bases that you could take leave, including just a doctor's recommendation that you not go to work or that you quarantine due to a health condition. New York State quarantine leave actually requires a quarantine order. And importantly, just this weekend, the governor issued a new executive order stating that if somebody who travels to one of the states, now we have quarantine required if individuals come back from the list of states that the governor keeps updating where it's hot spots right now. If employees voluntarily travel to one of those states, for example, the Carolinas, Florida, Texas, and then they come back to New York and they had gone to these places on vacation, let's say, they're not entitled to quarantine leave, even if they are subject to a quarantine order because of the voluntary nature of the leave. The same thing applies if it's one of the other countries identified by the CDC as a place that you need to quarantine from when you return. Those individuals would not be eligible for quarantine leave. The amount of time and pay that's available under New York State depends on the size of the business. And there's also the potential for New York paid leave, PFL, that we may know that as, which is an insurance that everybody must have that goes along with New York State disability insurance. And that is a possibility also for paid time if employees need to be out for themselves or to care for a child with COVID. Okay, we're going to move on now to dealing with employee fear and dealing with high-risk individuals in the workplace. This is probably the number one issue that I've been dealing with clients on probably a daily basis, sometimes several times a day. And the first issue is employees who are not high risk, and we'll talk about the high risk issue in one moment, but who are either simply afraid to return to work because of a generalized fear of sort of emerging from the cocoon that we've all been living in for the last several months, or I suppose, they would prefer to just stay home because they are collecting a sizable amount of unemployment. And sort of ironically, there are a lot of employees who are making more on unemployment than they would be if they're working. And so this disincentive to return to work is creating a significant issue for a lot of our clients who are trying to get these particularly low-wage earners back to work. So first, if it's just a generalized fear of returning to work, and of course, if it's just that someone wants to continue collecting unemployment rather than working, that's not protected. Somebody does not get to elect to stay, let's say, on furlough and collect unemployment rather than returning to work. So those people, you do not have to maintain their jobs if they just simply refuse to come in without a legitimate legal basis to stay out. However, people who are considered high risk by the CDC have a little bit more protection. And what that means in terms of high risk is somewhat of a moving target, and it's something that you have to keep your eye on because the CDC continues to update guidance concerning what underlying conditions are considered in terms of deeming somebody high risk. And they've also evolved the age component in terms of who constitutes somebody that's high risk, because while initially there was an age that they said, okay, anyone over, let's say 65 is high risk, the website now describes age that has been increasing. So the risk of getting significantly ill or death increases with age. So what the CDC is suggesting is that employers should protect employees who are at a higher risk for severe illness through supportive policies and practices. So those who are at high risk and who can continue to work remotely, the guidance suggests that you should allow people to do that if it is consistent and with your ability to continue to work from home. Other suggestions include offering vulnerable workers duties that might minimize their contact with customers or other employees. So for example, if there is a way to take someone who's high risk and give them an office space where they don't have to interact with as many either coworkers or the public, those are the types of things that are being recommended. Also, people who have a disability that might put them at high risk might be entitled to other types of accommodations. Like I mentioned with the prior slide, the Americans with Disabilities Act, New York State law, New York City law, and other local laws require employers to accommodate employees with disabilities. And that could be a physical disability, an underlying disease, immunocompromised situation, or it could be a mental health condition. Somebody who has, let's say, an anxiety disorder whose illness has been exacerbated by the pandemic might be entitled to an accommodation. And so the big thing that the EEOC and the New York State Division of Human Rights looks at, and that would be looked at in case there was ever a lawsuit, is did the company engage with the employee? Did they engage in what we consider the interactive process, whereby it doesn't mean you have to automatically give the employee exactly what they're asking for, but that you engage in a discussion with them concerning what their needs are, and perhaps with documentation to support that from a physician. And what is reasonable? What's a reasonable accommodation that the employer could provide? It may be staggering shifts. It might be working from home. It might be working partially from home. Any number of things could be an accommodation, but it's something that you have to engage with the employee in order to determine what might be available and does not constitute an undue hardship for the employer. Other possibilities include other unpaid leaves of absence under your own policies. So it's an important time to go look through your employee handbook and see what other leaves you have. some companies, particularly those who don't have FMLA because they're smaller than 50 employee workplace, might have other types of unpaid leaves in their handbook that might be available to employees. So you have to be careful to make sure that you're complying with your own policies to figure out what else might be available to employees. And then, of course, employees who do remain out of work may be entitled to unemployment depending on the situation. Okay, now we're going to move on to the final slide here, and this really is other possible pitfalls that may emerge from this new world of remote work and also the modified workforce that many people have, both in terms of coming back from furlough or continuing to work remotely or some combination thereof. The first is reviewing exemption classifications. So as most people know, employees are either deemed exempt or non-exempt, with non-exempt employees being entitled to overtime for hours worked over 40, with timekeeping obligations, and things of that nature. Exempt employees are generally those who are paid a salary and who meet certain duties requirements. That's obviously an overgeneralization, but generally speaking, that's the case. And what we've seen with the changed workplace is that some exempt classifications may have been jeopardized by some of the changes that have taken place. So two different ways that might happen. One is that, for example, when some employers have engaged in salary cuts or wage cuts during this time due to economic hardships. And so if an employee is earning a salary that is now less than the exemption threshold, that alone would mean that that person, as soon as they no longer earned a sufficient wage to be exempt, would be considered non-exempt, even though they're still making a salary. And so therefore, timekeeping processes must be in place and they would be entitled to overtime. Another way that an exemption classification could be impacted is the duties requirements. So for example, somebody who was a supervisor, in order to be a supervisor, an exempt supervisor, in addition to other duties requirements, the individual would have to be supervising at least 2 or more full-time employees at all times. Well, with remote work and with changes to employees who are furloughed, et cetera, you may have supervisors who no longer supervise 2 or more people at all times. If they do not meet those duties requirements, or again, the salary requirements, the exemption would be lost. So it's important to make sure that your classifications are proper. With regard to tracking hours of non-exempt employees, this is significantly more important when you have remote workers, because when you have a workplace that's only open, let's say from 9 to 5, and everybody is on site and everything closes after 5 o'clock, if for some reason you do not have a good timekeeping system in place, it's a little bit easier to backtrack to figure out what the hours are. It's always important to keep good timekeeping records, so I'm not suggesting otherwise, but it's even more important when you have people that are working remotely, because it is nearly impossible to go back and identify the hours that were being worked when somebody is working from out of the office. And off-the-clock work is one of the most significant wage and hour issues that we deal with because of this difficulty of being able to track the work. So whether you are continuing to have people work remotely, or you have, maybe having people work some hybrid of in-office and out-of-office, it's extremely important to make sure that you have good time tracking mechanisms in place. And finally, the last thing that has come out of this change in workplace that I'm going to address this morning is potential for other employee rights and benefits. So employees who are primarily working from home now may have a new primary place of work. And so certain things that would not have been applicable to those employees may now. So for example, in New York City, if you work for 80 or more hours in the city, you may be entitled to earn safe and sick leave, which does not apply if, for example, the individual works on Long Island. So now if their primary place of business is in the city, this may be a benefit that they're entitled to, and you as the employer have to think about whether or not you have employees that may be entitled to other rights and benefits that they weren't before because their workplace has changed. There may be also an impact on taxes and things like that, because if somebody's workplace is somewhere else, those are the types of things that may become an issue. So these are just a couple of the pitfalls. The best thing you can do is just try and engage in all of the best practices that we know, good timekeeping measures, make sure you have all of your safety plans in place and follow them to the best of your ability. And above all, everybody try to stay safe.
Thank you, Kim. Thank you very much. You know, it's interesting. You know, we've spent a lot of time over the past number of weeks discussing the Paycheck Protection Program, obviously loan forgiveness, and absolutely the applications that we're trying to work, help everyone through. So a lot of questions over the past number of weeks have been around that. And the reality is, COVID and everything else that we had spoken about, the FFCRA, the leaves, the antibodies, returning employees, none of this stuff goes away. And it was great. Thank you, Kim, for putting together the slides and the information to talk about all of this stuff, because, returning to work is something that we're going to constantly have to address, and new things are going to come about. We've seen a lot of really great questions come through as Carol and I are sitting here and taking a look at what's going on. And there's new stuff every week, and it just solidifies, how much information changes on a daily basis, and what we need to work on and get out to clients and businesses, really anyone that is listening to these webinars. So please continue to ask your questions. Please continue to visit these webinars, and we will do our best to get all of this information out to you and your employees the best way that we possibly can. So thank you again, Kim, for joining us on this webinar. Thank you, Carol, for going through the summary key points of the PPP. Again, this presentation will be posted on the COVID-19 Resource Center of our website. And we are continuing with our weekly communications to send out to everybody. Again, if you don't mind, take a look at the HR in 15 podcast, also can be found on our website. You can also see Kim there as well. And as always, please utilize your HRBPs, your payroll specialists, benefit specialists. Use your support teams with Prestige to help you through any questions that you have. Thank you again for spending some of your Wednesday morning with us for this webinar, and we look forward to speaking with everybody again soon.